Kate, you have an update for us on the Ninth Circuit insurance benefits claim that were filed by Armenian Genocide victims' families. Tell us about what's new with that story.
Yes, the court just came out, the Ninth Circuit came out with a ruling just at the end of August. It was a split decision where they dismissed the case because they found that the law that their claim was based on was unconstitutional. The district court found that the law was constitutional and did not dismiss the claims. And defendants, which are German insurance companies, filed an appeal, and a three-judge panel of the Ninth Circuit ruled with one judge dissenting that the law was unconstitutional because they found that there was an express federal policy prohibiting legislative recognition on the Armenian Genocide. It was an unusual ruling since they didn't even look at the merits of the California statute extending the statutes of limitations for such claims until 2010. They didn't look at the merits of the law. They just looked at the use of the word Armenian Genocide and said because prior presidents, Bill Clinton and George Bush, opposed congressional resolutions on the Armenian Genocide, that meant that they would also in turn oppose any state laws that use those terms.
So what does this mean for the case that was filed by Father Movsisyan against the insurance company?
Well, it was a setback, but now the plaintiffs are appealing this decision and seeking a rehearing of the three-judge panel or a full hearing before the entire Ninth Circuit, which is called an en banc review. And there was a hopeful development just a few days ago. The court ordered the defendants to respond to plaintiffs' appeal. And the majority of cases, the appeal requests are just summarily rejected. But it's a good sign that the court has asked the defendants to respond to the appeal, which is an indication that maybe they will rehear the case. They could still deny a rehearing, but it is a hopeful sign, and we're pleased to have seen that.
Okay. Kate Nahapetian, calling from Washington, D.C. and the ANCA office. Thank you very much. I'm going to ask you to join us again in 10 minutes to talk about a case in Massachusetts. Thank you, Kate. Welcome back to Horizon 180. On the phone with us again is Kate Nahapetian from the ANCA in Washington, D.C. And Kate, you've got an update on yet another important case out of Massachusetts. This one is about genocide denial. What is happening with this genocide denial in education case?
Well, the district court in Massachusetts issued its ruling in June of this year. It dismissed the case, which was a great victory for us because it's very rare to win a dismissal even before discovery has been ordered. It means that the court found that even if all the facts that the plaintiffs alleged were true, they still do not have a case.
So people wanted to teach education denial as part of the curriculum in Massachusetts. This was what the case was about?
Right. The Massachusetts passed a law asking the state to issue a curriculum guide on teaching of genocide in general, including about the Armenian Genocide, the Holocaust, and other instances of genocide. And it did not mandate the teaching of the genocide, just provided a curriculum guide for how to teach it. And the original guide did not include any denial materials, but after Turkish associations lobbied heavily, they were able to include websites that denied the genocide, including from the Turkish Foreign Ministry and the ATAA were sites that were included. And subsequently, they were removed after it was determined that they weren't, they went against the intent of the statute, which was to teach about the Armenian Genocide, not to deny it. And the plaintiffs then brought a case, specifically the ATAA, a Turkish American Association, brought a claim stating that their First Amendment rights were violated because their the denialist materials were removed from the
So
curriculum.
now in Massachusetts, the curriculum to teach about the Armenian Genocide moves forward as it was before this case.
Yes, it's always been, the court has never issued an order requiring the curriculum to be removed. Throughout the case, it's still being implemented. They weren't able to get a ruling preventing the use of it, pending the decision.
Very good news, Kate. Thank you very much. Kate Nahapetian from the ANCA calling from Washington, D.C. with an update on very important stories that we've been following on Horizon 180.